The United States has a long-standing pretrial legal tradition that is based on three key points. First, the Supreme Court has made it clear that pretrial release is the norm and detention is the carefully limited exception. The vast majority of people arrested and booked into jail on criminal charges should be released before trial. After all, they're presumed innocent and haven't been convicted of any crime. Second, pretrial detention should only be used as a last resort. In other words, only when no other option will work. That means that no condition of release, whether pretrial supervision, court date reminders, financial conditions, electronic monitoring, or anything else, will give us sufficient assurance that the person will not flee and will not endanger the public. Third, a person's liberty cannot be impinged without receiving full due process. And holding someone in jail, particularly before they've been convicted of a crime, is about as serious an impingement on liberty as you can imagine. Therefore, due process requires, at a minimum, a hearing in court where the person is represented by counsel and allowed to put on evidence, and where a judge makes findings on the record about the reason for their decision. And it's essential to get this decision right. If someone does not need to be in jail before trial, it is important that we not detain them. After all, research tells us that pretrial detention has enormous impacts on the detained person and on our system of justice. People who are detained pretrial are more likely to plead guilty or be convicted. If convicted, their sentences are likely to be harsher and longer. It costs states and counties an enormous amount of money to detain people, north of $14 billion per year, and it disrupts people's lives. Someone detained for even a short period can end up losing a job, their housing, or even custody of their children. As a result, detention can actually make it less likely that someone will return to court and more likely that they'll be rearrested. So the research echoes exactly what the Supreme Court has held. Liberty before trial must be the norm and detention the carefully limited exception. But does your system work that way? Are you releasing the vast majority of people pre-trial? Are you detaining people only when there's no set of conditions that would reasonably assure that the person won't flee and won't pose a threat to the community's safety? In most jurisdictions, the answers to those questions are no. Time and again, when jurisdictions look at who's in their jails, they find that they are detaining a lot of people charged with low-level offenses who seem likely to return to court and unlikely to do anything to harm community safety. And often, jurisdictions find that the people who might actually pose these risks end up being released. So, what's going on? There are, of course, many things that contribute to this situation, but in lots of places, there's really one central issue. We are asking judges the wrong question. What we should be asking is pretty straightforward. Is this person eligible for pretrial detention under state law? And if so, should they be released or should they be detained before trial? Now, that's not necessarily an easy question to answer, but that's why we have judges, to make those sorts of tough calls, like release versus detention. But we don't really ask them to do that today. Instead, in many jurisdictions, we ask judges, how much money should this person pay to get out of jail? That's particularly true in states and counties that rely on bail schedules that literally place a price on someone's freedom. If you face a particular charge, here's how much you have to post to be released from jail. But even where there are no bail schedules, there's a default assumption that many, if not most people, should be subject to financial conditions of release. And the more serious the charge, the more you have to pay. The problem with that approach is that it generates outcomes that no one wants, because it is not the judge who ultimately determines whether someone is released. It is that person's access to money or lack of access to money. So, how does this play out in practice? Well, let's look at two real-life cases. Khalif Browder was a teenager from New York City who was arrested in 2010 for allegedly stealing a backpack. A crime, certainly, but not a serious one by any definition of the word. His bond was set at $3,000. Mr. Browder's family could not afford that, so he was sent to Rikers Island. And he ended up spending 3 years there. 3 years awaiting trial. Ultimately, the charges were dismissed, so he spent 3 years in jail, nearly 2 years in solitary confinement, for an alleged crime that he was never convicted of. And tragically, a couple years after his release, he committed suicide. Now, let's contrast that story with Robert Durst. Mr. Durst was a New York resident who was widely suspected, though never charged, with killing his first wife in the early 1980s. After learning in 2000 that the case was being reopened, he moved to Texas. The following year, he was arrested there on charges of murdering and dismembering his neighbor. His bail was set at $300,000, exactly 100 times as much as Khalif Browder's. But here's the thing. Mr. Durst was rich. Rich enough, in fact, to post the $300,000 the next morning. He was released, fled to Pennsylvania, and eventually rearrested after a 6-week multi-state manhunt. Let's put this simply. This system makes no sense. Because in both of these cases, it's not that the judges made the wrong decision. They didn't look at Khalif Browder and decide that he should stay in jail for 3 years. They didn't examine Robert Durst and decide that he should be free the next morning. In fact, they didn't answer those questions at all, because that's not what they were asked. They were asked how much each of these men should pay to get out of jail. And it turned out that one of them had the money to get out, and the other one did not. So we ended up with a result that no one would want. Mr. Browder suffering in jail for 3 years over an allegedly stolen backpack, and Mr. Durst getting out the next day despite being accused of murder. These sorts of cases sometimes make the news when the details are just too glaring or too tragic to ignore. But some version of this is happening in jurisdictions all across the country every single day. And let's be clear about what this means. It means that people who, according to state and federal law, are entitled to pretrial release end up being detained. Not because a judge has decided they're eligible for detention under state law and that they're likely to flee or are dangerous, even though those findings are legally required. Instead, they're detained just because they cannot afford to post a bond. That, quite simply, is not what our federal Constitution says, not what most state constitutions say, and not what centuries of legal traditions say. That disconnect is why an increasing number of jurisdictions are rethinking their approach to pretrial release. They are working to develop systems where judges, rather than money, are deciding whether someone is detained. And they are achieving better outcomes, with more people staying in the community and succeeding while their cases are pending. So, what can your jurisdiction do about all this? Ask yourself some questions about your current system. How are decisions about pretrial release and detention made? Do bail schedules or financial conditions play a significant role in deciding who remains in jail before trial? Is detention the carefully limited exception while release is the norm? Are people provided with due process before they are detained? The answers to these questions can help highlight areas for you to focus on as you begin the process of pretrial improvement.